As most of you guys know, I've been negotiating and drafting contracts for about 30 years from my time at Shell and then into the legal practice. Our law firm handles contracts all the way from employment through acquisition of businesses, sale of businesses, with regard to intangibles such as software, anything basically that you can contract for to buy or sell or contract to provide services. Our firm provides expertise in that area. It is a practice area that we are very comfortable with, and we work with all of our clients on contracts that they have throughout their businesses. And it's an area that we feel very comfortable in handling. Eric, I know one of the areas that you work a lot on is employment-related contracts for executives when someone is being hired or potentially even separating from their company. Talk a little bit about the issues in an employment situation where we handle business contracts.
Sure. And that really depends on if we're representing the employer or the employer, because it's going to impact how you draft that contract. But generally speaking, if we're drafting a contract for an employer, they're bringing in an executive, we want to make sure, one, that the typical issues, compensation is handled, vacation days, the thing that you do with everybody else. But what's particularly important with an executive is non-compete issues, because he or she are going to be gaining critical information, proprietary information of that company. So one thing that you want to protect yourself from is that person working for you for a couple of years, gaining all the proprietary information, getting customer lists, prices, and being able to go somewhere else and repeat that same thing. So one of the key provisions, and it's also, sometimes it's even a separate agreement, but of an employment contract, is that non-compete issue, making sure that the employer is protected in the event that that executive goes somewhere else.
In today's world of intangibles, we're no longer operating in a world of tangible items and sales. We have a lot of things like internet software and website contracts and those sorts of intellectual property type contracts. When we handle those contracts for clients, Brian, tell me a little bit about the sorts of issues that we deal with in those contracts.
When it comes to things such as intellectual property, software, website use, the main objectives of that is to look at what are the terms, how are we going to protect our clients. So that includes what are the terms of use of that intellectual property, who's allowed to use it, how long are they allowed to use it, what are the rights and obligations of each party during that use. So when we're going through those contracts, we're simply looking to see how can we better protect our client against any potentially negative obligations.
Adam, in drafting of contracts, you have a lot of experience in the potential for litigation later on or dispute associated with that. So when we're drafting a contract, what sort of issues do you look at, or how do you address the potential eventuality of litigation under that contract?
When you're drafting and negotiating business contracts, you're typically dealing with kind of two competing concerns. One of which is, how do we get the parties to a place where they can agree and sign the contract now? And the other issue is that this is the document that the parties are going to be living under throughout the period of their relationship. And so you want to make sure that as you're going through drafting and negotiating the contract, that you are creating a system that is clear and very in a succinct and definite way outlines the obligations of the party, so that not only is your client in a strong position if a dispute does arise, but you're also looking forward to make sure that the obligations are set forth in a way that you can actually avoid litigation in the future by making sure that all of the rights and obligations of the parties are very clear.